All right, so welcome back to part 2. And now that we have the facts surrounding our sample real estate home purchase sale agreement deal, the first thing that we need to do is to determine the parties' major business goals. So now we're going to go ahead and discuss business goals for the home purchaser, the Rileys, the home seller, and the realtor. But this sample contract will be written from the perspective of the home purchasers, using the home purchasers' major business goals as a guide. But these principles can be applied to all of the parties to the deal, so this part of the course will give you ideas for how to negotiate and write a contract from the perspective of the home purchaser, the home seller, and the realtor. So I'm gonna jump right in, and it all starts right now. Now that we're ready to start writing the contract, I want to first introduce you to a deal memo. And now a deal memo can help you to organize all of the things you want to accomplish in the contract, your business goals, along with all of the specific details you need to actually draft the contract. Sometimes you may have had an initial meeting with the person on the other side of the deal. Well, you need to keep track of what was said during that meeting. You may do research on the parties to the agreement, the entities the other side may have, like their specific names, the specific names of a incorporation or a limited liability partnership. You want to have the legal names and the legal status of those entities. And so you may also want to do research on the financial standing of a person or entity. So you want to organize all of these details in one place, so you'll have them to assist you in the business issues worksheet analysis, as well as information that will need to be included in the final version of the contract. You will want to use your deal memo and your business issues worksheet together to draft the contract. So we've drafted a deal memo below for the No Addition Avenue historic home deal. So now let's take a look at it. Okay, so now here is our deal memo, and you're going to see these specific details that we'll want to make sure that we have when the time comes. So you're going to see things like your closing date. You're going to see information about the contract price, the purchase price for the real property. You're going to see who our players are and all of the critical information that maybe we have gathered about this particular party. The vital information like addresses, dates of birth, or whatever type of information that you may need to solidify the legal standing of the entity. Robert Jackson Realty is going to be the legal entity, and so you want to know and make sure that you have the status of that legal entity. The seller of the home is the Frank Lloyd Wright School of Architecture, Inc. So these are entities that you will want to do some research on so that you can do your due diligence and be ready at the time of closing or time of drafting the agreement. You will be able to use these details to fill in the fine details in the agreement. Now, because I always use the same contract sections framework with the same 10 contract sections, I always begin by just setting up my contract from this same template, allowing me to be able to just plug in the pieces, those contract concepts or problem solvers, into the proper contract sections of the agreement. So you want to see this example below. And so I would come in and set up this template here, and then I even put little notes about what must be reflected in each one of these sections. And so this is what needs to be included in the introduction. We'll talk a little bit about this right after I finish this particular part. We'll move right into talking about section 1, which is the introduction. And the introduction is made up of a preamble, or recitals, and words of agreement And so this tells me what needs to be in the preamble, what needs to be in the recitals. And so now I'm able to just come back in and just plug in what specifics information, some of which is probably going to come from the deal memo, the names of the parties, the consideration exchanged by each one of the parties. And then here in Article 2 or Section 2 of the contract are my definitions. And so it goes on like that throughout the entire agreement, all the way through to Section 10. So this is something that you may want to do. You want to go ahead and set up your template so that you can come back, drop your contract concepts into their proper place. Section 1, Introduction. Now that you have your deal memo and your business issues worksheet, you're ready to start drafting the contract, starting with Section 1, which is the introduction, or what we call the introductory provisions. So the introductory provisions include your preamble, recitals, and words of agreement. And then after the date, you want to state the parties. The preamble states who the parties are by doing two things. You want to identify the parties and you want to define the parties. And so let's first look at what we need to identify the parties. So by now, you should have confirmed the identities of the parties to the agreement by conducting that research I talked about. Now, this information should be included in your deal memo so that you can keep it, all of this vital information about the deal, all in one place. For legal entities like corporations, limited liability partnerships, etc., you should confirm the name and status of these entities with the Secretary of State in your particular state. For individuals, you should request their identifying documentation such as date of birth, social security numbers, address, state identification card numbers, or their driver's license number. It is critically important that the agreement is signed by parties who actually have the authority to bind each promise in the agreement. And in addition, in the event of breach, you want to be certain of the identity of the person or entity for easier processing of any litigation that may be required. It would be a shame to have to sue for breach of an agreement and learn after the judge signs the judgment that a party has been identified incorrectly. It absolutely does happen, and it takes a whole lot of work to fix. So the names of the parties reflected in the preamble should match exactly the names of the parties in the signature blocks that we'll talk about when we get to Section 9, which is where the signatures will be placed in the agreement. So below is an example of a proper Article 1 introduction or introductory provisions that reflect the specific goals and the facts of our real estate home purchase deal. Now, contract section 2 is reserved for the definitions in the agreement. In general, definitions are used so that every time you need to make reference to terminology in the agreement, you don't have to stop and provide the definition of that particular word each time it is referenced. And once you state the definition of what the particular word means, whenever you use that word throughout the agreement, it will have one meaning, which is the meaning that is stated in the definition section of the agreement. So even here in the definitions, we want to make reference to our major business goal. Remember, I stated that you should make sure that every section of the agreement makes some type of reference to your major business goal. So after the definitions, we move to the business actions section of the contract. And we start with the actions provisions first. The action provisions refer to the main business provisions of the contract. They contain the parties' business deal and their rights and obligations thereto. But more importantly, They include information on the subject matter, transaction or relationship, the money or other value that may be exchanged, the mechanics of when obligations will be performed, and the term of years or months of the agreement. Now, the first two provisions of the action section are your subject matter performance provision and your payment provision. Now, this section of the contract contains the premises on which the deal is based at the time of the signing of the agreement. The representations and warranties is about risk allocation. It assists the parties in making business decisions on whether to proceed with the deal or not. So your representations and warranties form the basis of the reliance that factored into the decision to enter into the agreement. For example, a car buyer wants the seller to represent and warrant that the seller owns the car and has the authority to sell it to the buyer. Okay, so here is our business issues worksheet. And remember again, here is where we're trying to control our risk. And so we want to control the risk of Mr. Jackson's statement not being true. And if that happens, we know that's going to happen after closing. So that's a large amount of risk that we want to make sure that we control. We're going to control it with the representation and warranty. Okay. And if that information turns out not to be true, then it will create a termination event. Okay, and then we will be able to control that. And by making the consequences of this termination event so high, it will result in a person making sure that they do not sign that contract if they cannot confirm that this information is true, or it makes it even more promising for a person to make sure that the information is true, because they don't want to suffer the debilitating consequences in the indemnities and remedies section of the agreement. And so this is where we're working from when we work on our representations and warranties. Now, and so here are our representations and warranties. You're going to have your sellers and realtors representations and warranties right here. Okay, this is where we want to tie that realtor into this agreement and get him to sign it, which will make him think twice about whether or not he needs to tell the buyers about any zoning regulations that he is aware of that could be actionable in the future. So what we have here is that seller and realtor represent and warrant to buyers that the seller and realtor are not aware of, have not heard of, and have not been notified verbally or in writing about any impediments that would preclude the construction addition that the buyers intend to build on the property. Seller and realtor warrant that the real property is suitable for the buyer's intended use, which includes construction on the real property. Your conditions to closing are the final check to ensure the parties' obligations have been fulfilled and the representations that are made at that particular time are true at the time of consummating the transaction. Now remember, conditions to closing is a section, a contract section, which is not the same as conditions, which is a contract concept used in various contract sections of the agreement. These are items that will just check and solidify that at the time of closing, these obligations and representations and warranties are all set. In essence, what we're saying is that all due diligence has been performed and completed, and the parties can move on with consummating the contract. Now, if you've enjoyed these tips, please give me a big thumbs up, and please don't forget to join me for part 3 of this series. But in the meantime, please subscribe to my YouTube channel and click the bell so you won't miss any of my tips. And please also follow me on TikTok and Instagram.